Hi, I'm Daniel Findling with Findling Law on thedivorceguy.com, and I'd like to talk to you today about an annulment. A divorce in Michigan is a legal breakup of the marriage. You're severing the marriage contract with a divorce. Unlike a divorce, an annulment is a judicial determination that the marriage never occurred. Now, in reality, that's just a fantasy because, of course, you were married. And it's also important to understand that a judicial annulment, that is a determination by the court that the marriage did not occur, is very different from a religious annulment, which is a determination by a religious entity like a church, a synagogue, or a mosque that the marriage did not occur. So what a church may determine in the eyes of God may in fact be more important to you than a judicial determination, which is simply the eyes of the court. Now, to get divorced in Michigan, you must allege simply that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. In fact, there are no specific grounds for divorce, merely that you want a divorce. For an annulment, there must be a specific ground. That is, from a judicial annulment, and they are not always easy to achieve. In fact, most people who call me and want to discuss an annulment, maybe because it's such a short-term marriage, are usually disappointed to find out that in fact they have to get divorced. Let's talk about the grounds for an annulment. It's first important to understand between a voidable marriage and a marriage that's void ab initio, a marriage that's void as a matter of law. There are certain marriages that are void ab initio, that is, void as a matter of law. And academically, you really don't need an annulment because in the eyes of the law, the marriage never occurred. But oftentimes, for whatever reason, maybe a real estate transaction or merely for your own well-being, you want that judicial determination that the marriage is annulled, that the marriage, even though it never occurred in reality in the eyes of the law, you still may want that piece of paper. So what are marriages that are void as a matter of law? Even if you went through the ceremony, all the pomp and circumstances, Michigan will still not recognize the marriage ever. A bigamous marriage, a marriage to somebody who is already married to somebody else and not divorced, is void as a matter of law. You cannot be married to more than one person. So if you married somebody who is already married, you don't even need an annulment because your marriage is void as a matter of law. A marriage to somebody who is under the age of legal consent is void ab initio. Now in Michigan, you have to be 18 to legally married. Certainly with parental consent, there are some exceptions. You can get married at 16. The statute is, I think it's MCL 552.103 that describes the age to be married. But realistically, you need to be 18 to legally married in Michigan. So if a 13-year-old gets married and has a marriage certificate signed, the fact is they never have been married, okay? You don't even need an annulment because it's void ab initio. A marriage to a close family member, such as a mother, sister, grandmother, daughter, granddaughter, stepmother, grandfather's wife, son, these are all void ab initio. A marriage to a close family member are void as a matter of law. Now, there are circumstances where a marriage to a close family member may have been legal in another state. You know, the jokes always say, oh, I married somebody in Tennessee or Kentucky or Alabama. I married my cousin. You know, in fact, if it is legal in another state, it isn't void ab initio, void as a matter of law. For example, if you married your first cousin in Tennessee, as the jokes may go, that marriage will be recognized in Michigan. However, it is voidable. You can file an annulment action and ask that that marriage be voided, that is annulled, a judicial determination that never occurred in Michigan. Other types of marriages that are voidable by filing an action for an annulment are marriages by fraud, force, or duress. So if you're fraudulently induced to marry for some reason, you certainly can ask that the marriage be voided, that a determination that it is annulled. If the marriage was under duress. By way of example, the most obvious form of duress is somebody had a gun to your head and said, listen, you're marrying me right now. You go through the ceremony, you sign the marriage certificate. The marriage is valid, however, it is voidable. We can file an action to annul the marriage. And as I described just a few moments ago, if a marriage is valid in another state, but invalid in Michigan, it's voidable. You can file an annulment action. All right, and then that was the example of a close family member. Now, in sum, most people are disappointed when they hear that their short-term marriage that they thought was a mistake cannot be annulled in Michigan, under Michigan law. Merely because you made a mistake is not a ground for an annulment. It may be a ground for a religious annulment in the eyes of God, and oftentimes it may be a better course of action, if you're religious for that matter, to go to your priest or your clergy or your rabbi or your imam and say, I want a determination in the eyes of God that the marriage did not occur, that you were annulled. But from Michigan's perspective, oftentimes we have to steer that individual into divorce. I'm Daniel Findling with Findling Law and thedivorceguy.com. If you have additional questions or concerns, I invite you to call me at 248-399-3300 or visit us on our website, thedivorceguy.com.